light will display green when you're hot.
The Subcommittee on Financial Institutions and Monetary Policy will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Consumer Financial Protection Bureau Ripe for Reform. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. I now recognize myself for 5 minutes to give an opening statement. Thank you to our witnesses for joining us today in the Financial Institutions and Monetary Policy Subcommittee to discuss the administrative process fouls and structural issues that make the CFPB ripe for reform. Today's hearing will examine the agency's leadership structure, current funding mechanism, and how the agency manages its budget, operations that are in need of reform, and current tactics of regulation without rules. Leadership structure. The CFPB does not have an executive board, an independent inspector general, or any true oversight of the director. This is unlike virtually every other federal agency. The agency is led by a single partisan director, Mr. Rohit Chopra, who has routinely acted unilaterally and arbitrarily, often outside any statutory mandate, without engaging in rulemaking in compliance with the Administrative Procedures Act, and even sometimes without adjudication. This has led to the CFPB becoming the most unchecked, unaccountable agency in the entire federal government. Funding mechanism and budget. Further, the CFPB operates outside of the congressional appropriations process, receiving its funding through the Federal Reserve through an opaque and arbitrary formula, operating obviously outside of the traditional appropriations process. This denies Congress the use of its most powerful oversight tool, the power of the purse. My legislation, the Taking Account of Bureaucrats Spending Act, or the TABS Act, would give Congress the power of the purse and its oversight power, reining in the unaccountable CFPB and subjecting the agency to the traditional appropriations process. As many of you all know, the U.S. Court of Appeals for the Fifth Circuit recently held that the funding mechanism is unconstitutional, stating that it is, quote, double insulated, as the Fed and CFPB both operate outside of the congressional appropriations process. The Supreme Court will review the Fifth Circuit's decision this fall and has the opportunity to clarify the constitutionality of the CFPB's funding once and for all. The TABS Act provides a common sense solution for questions surrounding the funding mechanism and will put an end to bureaucratic overreach, and we hope will earn bipartisan support once it becomes clear that this legislation is the way to save the agency. Additionally, the Fed does not exercise authority over the CFPB in terms of its budget. Instead, the director is required to merely submit a short letter requesting funds each quarter that the director alone decides are reasonably necessary for operations. The Fed rubber stamps the request each time. This unchecked budget process allows for no accountability over the agency, which in turn permits the agency to stray from its core mission. This process must be reformed. Regulation without rules. Under Director Chopra, the CFPB has begun regulating without rules by evading the traditional notice and comment process. Instead, rulemaking through enforcement, blog posts, and press releases, changes to examination manuals. Not only does this circumvent the requirements of the APA, which provides for public input and prevents whiplash for industry with each change in leadership, but it also does not promote lasting policy directives and is harmful to consumers' access to financial services. Recently, the CFPB has failed to fulfill its statutory obligation to comply with the Small Business Regulatory Enforcement Fairness Act, SBREFA, which is required when a rule may have significant economic impact on small entities. Evading this statutory obligation is not only unacceptable from a process standpoint, but also disadvantages small institutions who serve consumers the CFPB is charged with protecting. In addition to the TABS Act today, we will examine other bills that reform the CFPB's leadership structure by establishing an independent IG and creating a multi-member bipartisan commission. Focus on the requirements for funding the agency's budget, require more oversight and quantitative analysis of the rulemaking process, and protect small businesses and whistleblowers. These bills are the first steps toward reforming the unaccountable CFPB. I look forward to discussing these issues and hearing from our panel today on what reforms will be beneficial for the agency and for consumers. With that, I will yield back my time, and the chair will now recognize the ranking member of the Subcommittee on Financial Institutions and Monetary Policy, the gentleman from Illinois, Dr. Foster, for 4 minutes for an opening statement.
Thank you, Chair Barr, and thank you specifically for starting this hearing exactly on time. We're setting a great precedent. We're here today to discuss ways that we might, quote-unquote, reform the Consumer Financial Protection Bureau. Reform is an interesting word, which can be taken as to improve, to alter, or to abolish. And if past his prologue, I am afraid that I may hear from my Republican colleagues not ways in which we can improve the CFPB, but ways in which we can weaken or handicap it. And many in the Republican Party have fought against the CFPB since its inception, repeatedly seeking ways to delegitimize, defund, or most recently, to abolish the agency entirely. The CFPB's funding mechanism is the latest spearhead of this attack on one of our nation's most important financial regulators. This has far-ranging implications, carrying with it the danger of invalidating crucial consumer protection rules that our constituents have relied on for the past decade. This threat does not end there, however, because the CFPB's funding structure is not unique. The FDIC, the OCC, the Federal Reserve all share the same basic funding mechanism and will be equally threatened if the CFPB's funding is ultimately found invalid. Republicans have effectively launched an attack that could imperil much of the financial regulatory infrastructure that has saved the U.S. economy in 2008 and again in 2020. The Fifth Circuit Court has crafted a theory that would empower courts to strike down mandatory spending on federal programs, compelling Congress to either reappropriate the money each year or let the program die, the very embodiment of Republicans' plans to, for example, sunset Social Security. This radical reading of the Constitution could also threaten Medicare, Medicaid, as well as Social Security, and the Affordable Care Act, unemployment benefits, child nutrition assistance, and so much more. This decision specifically threatens to inflict immense legal and practical harm on not just the CFPB, but to consumers and our nation's financial sector, who have invested billions of dollars into a compliance regime that ensures that the vast majority of good actors in financial services do not have to suffer from competition from bad actors. The CFPB has more than a decade-long track record of working around the clock to fight for our nation's consumers. Consumer protection should not be a partisan issue. Since its inception, the CFPB has returned more than $16 billion back to 192 million harmed consumers and has held bad actors accountable to the tune of nearly $4 billion. Moreover, roughly 80% of polled U.S. citizens support the CFPB and want the agency to continue its job. So my friends across the aisle would be wise to listen to their constituents and work in a bipartisan way to truly improve the CFPB and not to handicap or abolish it. As American families are emerging from struggles of the pandemic, now is not the time to weaken consumer protection. The CFPB is integral to that goal, and I look forward to discussing how we can support its mission to protect our constituents. Thank you. Yield back.
The gentleman yields back, and the ranking member, I think, expressed an interest in giving an opening statement, but I do not see her. And so with that, we will move on to the testimony of our witnesses. Today, we welcome the testimony of Mr. Bill Hempler. Mr. Hempler is President and CEO of the American Financial Services Association, founded in 1916. The AFSA is a trade association for the consumer credit industry, protecting member companies' ability to offer affordable credit options to American consumers and enhancing consumer choice. Mr. Brian Johnson, who is familiar to this committee, he is the managing director in the Banking Supervision and Regulation Group at Potomac Global Partners. He previously served as deputy director of the CFPB, where he oversaw the agency's rulemaking, supervision, and enforcement activities. He conceived and led the creation of high-profile agency initiatives, including the Office of Innovation, Task Force on Federal Consumer Financial Law, Policy Symposia Series, and Start Small, Save Up Emergency Savings Program. Ms. Jessica Thompson. Ms. Thompson is an attorney in the Economic Liberty Practice Group at the Pacific Legal Foundation. She has litigation experience in a variety of state and federal constitutional law issues, presenting constitutional challenges to the CFPB and COVID-19 related executive actions. She also engaged in appellate advocacy for clients challenging removal protections for SEC administrative law judges, and submitted amicus briefs on judicial deference to state Supreme Courts. Mr. Devin Watkins. Mr. Watkins is an attorney at the Competitive Enterprise Institute, where his expertise focuses on government transparency and regulatory reform. Mr. Watkins previously worked at the Cato Institute as a legal associate and interned at the Institute for Justice. Another witness who has familiarity with our committee, Mr. Attorney General Keith Ellison. Good to see you, my friend. Welcome back to the committee. Mr. Ellison was sworn in as Minnesota's 30th Attorney General on January 7th, 2019. From 2007 to 2019, Keith Ellison represented Minnesota's 5th Congressional District in the U.S. House of Representatives, and he served for 12 years on the House Financial Services Committee. We thank each of you for taking the time to be here. Each of you will be recognized for 5 minutes to give.
Mr. Chairman, may I have a point of personal privilege, please, before you start?
The gentlelady's recognized.
Thank you for 1 minute. Mr. Chair, I'd like to ask unanimous consent to take a point of personal privilege to welcome back our former colleague, Attorney General Keith Ellison. Thank you, Attorney General Keith Ellison, and welcome back. As many of you know, you served on this committee when we created the CFPB through the Dodd-Frank Act, and you are now Minnesota's Chief Law Enforcement Officer. You are just the right person to help us discuss the issues that this hearing is focused on. So we're glad to have you back here in our committee room. We're looking forward to your testimony. Mr. Chairman, I would like to request on behalf of our ranking member to enter this statement for the record from the following organizations who are in support of preserving the CFPB's current leadership structure, funding the mission to protect consumers. They are the American for Financial Reform, the Center for Responsible Lending, the National Association for Consumer Advocates, the National CAPACD, and the National Community Reinvestment Coalition, Public Citizen, Prosperity Now, USPIRG, Woodstock Institute, 2020 Vision, DC.
Without objection.
Thank you,
that
Mr.
will be made
Chairman.
part of the record. And also without objection, each of the witnesses' written statements will be made part of the record. Mr. Hempler, you are now recognized for 5 minutes for your oral remarks.
Thank you, Mr. Chairman, Ranking Member Foster, and members of the subcommittee. My name is Bill Hempler, and I'm President and CEO of the American Financial Services Association, which represents the consumer credit industry, protecting access to credit and consumer choice. And I must say, I'm glad, Mr. Chairman, that you got the real smart attorneys on the panel with me here. I appreciate the opportunity to testify before the subcommittee to demonstrate how the CFPB's refusal to operate within its congressional mandate and its unhelpful rhetoric harms both consumers and creditors. Instead of a path that exceeds its authority, I would suggest an alternative path for the Bureau. But allow me to share 5 examples of how the Bureau's overreach, which could have detrimental effects on how the American consumer safely accesses credit and could throw the entire consumer credit market into disarray. First, the CFPB seeks to impose limits on arbitration despite Congress's overturning its arbitration rule and the Bureau's own study and research that shows that arbitration benefits consumers. The CFPB continues to pursue efforts to eliminate arbitration agreements, this time by proposing a non-bank registry that would require finance companies to register certain terms and conditions, such as arbitration agreements. This proposal is unnecessary because the information is already publicly available. In addition, it will only serve to shame companies from using this lawful tool and give trial lawyers a roadmap for class action lawsuits that pay consumers $3 or $4 per case, while the lawyers make millions. By comparison, consumers actually receive several thousands of dollars in arbitration settlements. Second, the Bureau focuses on press releases over rules, meaning that struggling consumers remain just that, struggling. The CFPB has issued press releases on so-called junk fees without defining what they are, while some, such as resort fees and ticket fees, are clearly outside the CFPB's jurisdiction. This leads to greater compliance uncertainty, thereby limiting consumer choice and credit access. In short, the Bureau's rhetoric accomplishes absolutely nothing for the consumer. If the Bureau has identified a problem, in the consumer finance marketplace, it should follow APA rulemaking authority that's at its disposal and institute real change. Third, regulation by press release can have serious consequences for consumers. In December, the CFPB issued a press release on the Service Member Civil Relief Act, or SCRA. The press release ignores this SCRA's statutory requirements, fails to account for the impact that the proposal will have on the securitization market, and does not address the failings of the Defense Manpower Data Center SCRA website. If creditors followed the Bureau's recommendations, it could have dire financial and privacy consequences for service members that the CFPB could have foreseen if it had engaged in APA rulemaking. Fourth, the CFPB is using regulation by enforcement to change the decades-old truth in lending with little concern for the harm that it could cause consumers. Under Dodd-Frank, the CFPB has the authority to amend Reg Z, which implements TILA. A joint CFPB New York Attorney General enforcement action, however, attempts to create an ability to repay standard for vehicle finance and to punish companies for an unacceptable default rate, despite the fact that there is neither an acceptable default rate nor an ability to repay standard in any law or regulation governing vehicle finance, or the fact that the proposal is unworkable. Such changes in the credit practices could substantially limit availability and likely eliminate approximately $20 billion in subprime auto credit market. Fifth, the CFPB's misinterpretation of the Military Lending Act would have harm to the service members it seeks to help. The MLA excludes vehicle finance, but CFPB is attempting to end run around Congress's clear intent by bringing vehicle finance under the Military Lending Act. If the Bureau's interpretation stands, it could have serious consequences for loans that are already in the marketplace and could limit service members' ability to get credit going forward. Instead of going after well-regulated financial institutions and products, the CFPB should pursue bad actors such as credit repair organizations, which provide no benefit to consumers, cost the consumers significant money up front, may damage the consumer's credit worthiness, and actually divert resources from legitimate disputes. Absent its members are committed to serving consumers in a well-functioning marketplace, and we agree with Director Chopra that markets work best when rules are simple, easy to understand, and easy to enforce.
The gentleman's time has expired.
Thank you, Mr. Chairman.
Thank you. Mr. Johnson, you're now recognized for 5 minutes to give your oral remarks.
Chairman Barr, Ranking Member Foster, and members of the subcommittee, thank you for holding this important hearing on reforming the Bureau of Consumer Financial Protection. I'm Brian Johnson, Managing Director of Potomac Global Partners, a financial services regulatory consultancy. I previously served as the Deputy Director of the CFPB, and prior to that served for more than 5 years as a staff member for the Financial Services Committee. The CFPB has an important statutory purpose, and when properly structured and managed, it can fulfill that purpose. It can support free markets and promote consumer choice and economic opportunity while protecting consumers. Notwithstanding the admirable work of many of its staff, the CFPB has not reached this potential, which is why today's discussion is so important. More than 12 years since its creation, we now have a track record by which to judge this agency. But what yardstick should we employ to measure the Bureau? While reasonable people can and do disagree about the policies and processes the CFPB employs in pursuit of its mission, we should all agree that its activities must follow the objective rule of law, and its actions must remain within the authorities set by statute by Congress. Measuring the extent to which the CFPB has adhered to the rule of law can help determine the need for reform and the contours those changes should take. In taking measure of the Bureau, my written testimony lists many examples when the agency exceeded its statutory authority and operated beyond the limits of the law and our Constitution. Examples include an unconstitutional funding structure and removal protections of its director, as well as the Bureau's disregard for due process, failing to properly notify those subject to investigations, and proposing to restrict First Amendment rights. The CFPB has also aggressively sought and at times used powers not authorized in statute, ignoring limits placed on it by Congress. My testimony goes into greater detail on how the Bureau has claimed authority to examine institutions for compliance with laws beyond those statutes assigned to it, has attempted to apply law governing applications for credit to non-applicants, and sought to regulate auto dealers despite a statutory exemption from its authority. This litany, further detailed in my testimony, is by no means exhaustive, and I take no pleasure in repeating it here. While one or two of these examples could perhaps be dismissed, the frequency with which these issues arise demonstrate the CFPB is ripe for reform. There are many worthy legislative proposals, but I will focus on those which reestablish the separation of powers or other checks and balances, and therefore are most apt to preserve the rule of law and protect our liberties. First, Congress should consider reforms to the funding structure of the CFPB. In my experience, there is no oversight of CFPB's spending. This arrangement tempts directors into pursuing initiatives that bear little relation to the priorities of the American people, nor to the boundaries of its statutory authority. Placing the Bureau on appropriations would refocus its efforts and better align them with all Americans' needs and desires. Second, Congress should determine the CFPB's primary purpose and consider what structure serves that purpose best. Our framers wisely designed the executive branch to be unitary, so it may act with decision and dispatch. They also recognize that the creation of rules and law require careful deliberation to balance and represent the diverse interests of our citizens, and so created Congress to have many members. The same lesson can be applied to the CFPB. If you wish for the agency to simply enforce consumer laws, there may be good reason for it to remain headed by a single director. If you wish for it to instead exercise your delegated legislative powers through rulemaking, then its deliberations may benefit from multiple commission members who can deliberate and better reflect a diversity of views and interests. Together, these basic reforms can enhance the legitimacy of the Bureau and help it achieve its promise. Again, I applaud the subcommittee for having this discussion and acting on its responsibilities to build a stronger CFPB that better adheres to the rule of law and better reflects the consent of the governed. Thank you, and I welcome the opportunity to answer questions you have.
Thank you, Mr. Johnson. And now, Ms. Thompson, you are recognized for 5 minutes to give your oral remarks.
Chairman Barr, Ranking Member Foster, and honorable members of this subcommittee, thank you for the opportunity to testify at this hearing on why the CFPB is in desperate need of reform. My name is Jessica Thompson, and I'm a constitutional litigator in the separation of powers practice at the Pacific Legal Foundation, where we defend Americans' liberties when threatened by government overreach and abuse. I'd like to share 3 points. 1, CFPB's current funding mechanism is unconstitutional. 2, CFPB uses consent orders to evade the APA rulemaking process. 3, my client's recent victory illustrates CFPB's pattern of overreach. First, in contrast to CFPB's recent arguments in briefing before the U.S. Supreme Court, CFPB has always described itself as a non-appropriated independent agency. This dual-level exemption from the appropriations process plainly violates the Appropriations Clause of the U.S. Constitution. The second thing you need to know is that without meaningful oversight and the accountability that accompanies congressional appropriations, CFPB is free to evade the normal rulemaking process by using consent orders to announce new legal theories. Although these theories are often untested in court, CFPB claims consent orders are precedential guidance for regulated institutions. This presents constitutional concerns for due process, undermines the rule of law, and will limit consumers' access to financial services. My third point illustrates the risk of constitutional harm from an unaccountable agency. At Pacific Legal, we're helping Americans fight CFPB's unconstitutional overreach and recently secured an important win for our client, Townstone Financial, and its owner, Barry Sterner. Last month, a federal court held that CFPB's interpretation of its own regulation went beyond the authority granted to it by Congress in the Equal Credit Opportunity Act. CFPB was so far over its skis that the judge dismissed the case with prejudice. Faced with an enforcement action based on a novel interpretation of a nearly 50-year-old regulation and allegations of redlining, Townstone faced immense pressure to enter into a consent order. But Townstone never discriminated against any applicants for credit, and the CFPB didn't even allege that it had. Instead, CFPB claimed that Townstone violated an agency regulation with statements about crime it made on a weekly radio show it hosted on a conservative station. As even Mr. Sterner would admit, it's difficult to talk for an hour about mortgages alone. Conversation on the show would often turn to local and national news, and in Chicago, crime is a frequent topic of conversation. In the show's history, Townstone never received a complaint about its discussions, and CFPB could not identify anyone who claimed to be discouraged from seeking credit. But that didn't stop CFPB from plucking 5 innocuous statements about crime and life in Chicago out of hundreds of hours of radio broadcast to allege that Townstone intended to discourage African Americans from seeking credit. Luckily, Townstone had the courage to challenge CFPB's untested legal theory in court, and with pro bono assistance from Pacific Legal, the wherewithal to sustain the legal fight for 6 years. The court's rebuke of CFPB's overreach in the Townstone case is a huge win for the separation of powers. But we need Congress to act to prevent others from going through the abuse that Townstone and Mr. Sterner suffered. In closing, Pacific Legal urges Congress to bring CFPB within the annual congressional appropriations process to protect consumers' access to financial services and the rule of law. Once this essential element of checks and balances is restored, Congress should conduct oversight over the broad powers delegated to CFPB to ensure its regulations and enforcement actions do not exceed its authority or trample constitutional rights. Thank you again for this opportunity. I look forward to answering your questions. I'll yield the remainder of my time.
Thank you, Ms. Thompson. And now, Mr. Watkins, you're recognized for 5 minutes for your oral remarks.
Thank you. Chairman Barr, Ranking Member Foster, and members of this subcommittee, I appreciate the opportunity to speak to you today. My name is Devin Watkins. I'm an attorney at the Competitive Enterprise Institute. One of our principles is that government agencies should face democratic accountability to elected officials so that people can live freer, healthier, and more prosperous lives. That vision is needed today more than ever, especially for the Consumer Financial Protection Bureau. Today, I will focus my testimony on 3 critical reforms of the CFPB. All 3 of them implicate fundamental constitutional rights. These 3 reforms are ensuring congressional appropriations, ending regulation by enforcement, and prohibiting fines without juries. First, the most critical CFPB reform is ensuring congressional appropriations. The Dodd-Frank Act bypassed congressional appropriations to avoid Congress's oversight of the CFPB. This is a direct affront to democratic control and public accountability. Founders wanted to prevent the lack of accountability that occurred when the King of England bypassed the legislature to control government funds. That's why the Constitution requires that no money shall be drawn from the Treasury but on consequence of appropriations made by law. Congress alone is responsible for determining the budget for government agencies. Indeed, the Supreme Court decision to consider the constitutionality of the CFPB's funding mechanism suggests some possibility that the court will decide that only Congress may fund federal agencies. Congress should scrutinize all other funding mechanisms with an eye towards returning to the congressional appropriations system. The second critical CFPB reform is prohibiting the practice of regulation by enforcement because it contradicts the rule of law. Instead of providing clear rules for people to comply with, the CFPB requires individuals to anticipate what the CFPB director considers unfair and abusive. This method is similar to setting the speed limit as a reasonable speed and then allowing officers to issue tickets based on their subjective judgment of what a reasonable speed is. It leads to arbitrary punishment and leaves no way for regulated parties to ensure that their conduct remains lawful. The determination of what violates the law shouldn't be done by blog post. The regulated community should receive notice of what is illegal by Congress or through the rulemaking process that was laid out by Congress. This means a requirement that a rule existed that clearly and convincingly demonstrates that some given action is illegal. This means guidance issued by the CFPB would be limited to explaining what conduct is lawful. Constraining the CFPB in this way would block the agency from sneaking in new regulatory requirements through guidance documents. Finally, the CFPB should end the practice of issuing fines without jury findings of wrongdoing. Seventh Amendment mandates that in suits at common law, where the value of controversy shall exceed $20, the right of trial by jury shall be preserved. Common law remedies, such as fines more than $20, must be determined by a jury. The Seventh Amendment exists because the government can abuse monetary penalties, so the jury system acts as a backstop to prevent such abuse. The Declaration of Independence cited as one of the causes of American independence is the English government, quote, depriving us in many cases of the benefits of trial by jury, end quote. And John Adams recognized that, quote, representative government and trial by jury are the heart and lungs of liberty, end quote. Nevertheless, the CFPB regularly fines individuals without allowing them a jury. Instead, the CFPB uses administrative law judges to determine if people have violated the law. But it is the CFPB that appoints, oversees, and can fire these judges at any time. How can any ALJ be impartial if their livelihood depends on one of the parties before the judge, not removing them from office? Whenever a citizen of this country is punished, only their fellow citizens and a jury should make that determination. These three issues are the most critical reforms to the CFPB. The time for reforming the CFPB is now. Delaying action at the CFPB will result in more harm, both to consumers and to industry. Thank you for the opportunity to testify today regarding this timely and important issue.
Thank you, Mr. Watkins. Mr. Ellison, you are now recognized for 5 minutes to give your testimony.
Mr. Chairman, thank you, and allow me to also thank Ranking Member Foster. Ranking Member Waters is not here, but I do thank
you.
her as well.
Is your mic on? Okay, there we go.
Yeah.
Thank you.
And let me just say that it's good to be back with the Financial Services Committee again. After 12 years of being your colleague, it was certainly an honor and a joy, and it's good to be back with you. I remember well September 2008, and I know many of you do too as well, when President Bush's Treasury Secretary said, we need $700 billion by Monday or the economy is going to collapse. We can argue whether that was accurate or not accurate, but that was what we were told, and that's what we dealt with. Let me tell you, the CFPB is part of our response to that financial crisis, and the CFPB has been a wonderful partner to state attorneys general and to American families. Let me remind everybody, the CFPB exists because we had 4 million foreclosures. We had over $1 trillion in home value losses and blighted neighborhoods, houses with copper wiring ripped out. We are not here. We don't have a CFPB because somebody just thought it would be a great idea. We're here because of a financial crisis. Let me begin by discussing a case in Minnesota that we worked with the CFPB. Back in October 2019, my office, alongside the CFPB, North Carolina, and the City of Los Angeles City Attorney's Office, sued a series of companies and individuals running a fraudulent student loan relief scam that falsely promised to help people pay off student loans and obtain student loan forgiveness in the process. In this time, when over 40 million Americans owe $1.75 trillion in student loans, these companies preyed on over nearly 90,000 desperate consumers and illegally collected over $95 million in fees from them. Together, we shut them down, and this past December, issued refund checks to the consumers. Without the CFPB, we wouldn't have been able to get that result. Not only did the Bureau provide resources to give us the bandwidth to bring the case, but it's only because of the CFPB's civil penalty fund that we were able to secure $95 million in refunds to compensate victims when the companies and the people we sued couldn't afford to pay the full amount. If not for the CFPB, consumers would likely have received only a fraction, if anything. I fear this example shows exactly why we need the CFPB and why some people are hostile to the CFPB. This is just one example of the dozens where states like Minnesota have joined with the Bureau to act against companies and hold them accountable for defrauding consumers. Companies being held accountable sometimes don't like being held accountable, And sometimes that will explain the scenario we have today. It's not a matter of politics. It's not a red and blue issue. The CFPB has joined together with states, regardless of politics, to stop fraudulent actors. Let me give you an example. All 50 states joined the CFPB in suing the country's largest mortgage companies for numerous unfair and deceptive practices related to servicing borrowers' mortgages. In 2021, Georgia joined with the CFPB, suing a company offering fraudulent credit repair and debt relief services. And in just the last 3.5 years, Arkansas, South Carolina, and others have joined the CFPB on more than one occasion. These cases get meaningful results for consumers. As a result, at the end of 2022, the CFPB has recovered $16 billion for consumers, obtaining $192 million for consumers nationwide. But what consumers gained? Somebody on the other side of the transaction lost, and they're not happy about it. States like Minnesota have historically served at the forefront of efforts to protect consumers against fraudulent and abusive practices. And for over a decade, the CFPB has served as a critical enforcement partner for us in our efforts. The CFPB has also been a partner to American families struggling to make ends meet when they stand up against a Goliath in the form of a financial services company. Congress intended to create a CFPB in response to this 2008 financial crisis, as I noted, and it should remain. But the Bureau doesn't just sue alongside states. It is essential in acting as another cop on the beat for consumers, particularly in targeted areas where
The gentleman's time has expired. And if you could just wrap up real quickly.
Thank you, Mr. Chair. I will do that. Let me be clear, the CFPB is a critical partner, and we certainly believe that their continued success is essential to protect consumers and families.
Thank you, Mr. General, and we'll now turn to member questions. The chair now recognizes himself for 5 minutes for questioning. And as I mentioned in my opening remarks, I've introduced the TABS Act to place the CFPB under the congressional appropriations process, restoring the power of the purse and vindicating the separation of powers doctrine. Mr. Watkins and Mr. Johnson, please amplify your testimony how the CFPB's double insulated funding mechanism is unconstitutional and allows the CFPB to stray from its statutory mission and evade proper oversight. And as you answer that question, please also address these sky is falling concerns that the Supreme Court, if it upholds the Fifth Circuit decision, that this would call into doubt the constitutionality of all these other self-funded federal bank regulators, including the Federal Reserve, the FDIC, the FHA, FAA, et cetera.
So I'll begin. So in my view, when the Constitution says no money shall be drawn from the Treasury, but in consequence of appropriations by law, what it meant by Treasury was public money. It was money that government owns, and that includes all the money that the CFPB uses to fund its operations. And when it says that Congress needs to appropriate that money, it means Congress needs to decide the budget of the CFPB, not the director of the CFPB. That is a decision that Congress and Congress alone must make. And so that's really critical from an accountability standpoint. But I do think that it isn't just the CFPB. There are other agencies out there that do have non-appropriated funds, and Congress should review those as well and think about how to return those agencies to congressionally funded appropriations process as well.
And Mr. Johnson, do you believe that the CFPB's unique novel funding mechanism is distinguishable from these other self-funded federal financial regulators?
Thank you, Mr. Chairman, for the question. So, one of the interesting arguments that was made in the cert petitions before the Supreme Court was whether or not the Bureau's funding can be distinguished from similarly situated federal regulators, and I believe it can. The Fifth Circuit certainly cited the double insulation unique structure, but fundamentally the CFPB is differently situated than the FDIC, the NCUA, the Fed, the OCC, in as much as each of those agencies has been assigned by Congress a safety and soundness mission. In other words, they're prudential regulators. And they provide a service to banks in the form of guaranteeing liabilities through deposit insurance. And they supervise institutions for safety and soundness to guard against the risk to taxpayers. And it may be appropriate for Congress to establish funding structures for those agencies to recoup the cost of that supervision from the banking institutions that are supervised by those agencies. The CFPB, contrary to those missions, is fundamentally a market conduct regulator. It has no safety and soundness mission. Fundamentally, the Bureau has no obligation to ensure the continued operation of institutions as an ongoing concern. It is simply there to supervise institutions for compliance with a discrete set of federal consumer financial laws. And so market conduct is distinct from prudential regulation, and it's a fundamental difference that I think should be accounted for in consideration of the Bureau's funding.
Thank you, Mr. Johnson. And another question for you. Since Director Chopra has taken over the Bureau, we've seen a new tactic of regulation without rules. For example, last month, when putting out a notice for proposed rulemaking on credit card late fees, the Bureau failed to fulfill its statutory obligation to convene SBREFA. Also, in March 2022, the Bureau updated its UDAP exam manual as a way of evading notice and comment. Can you explain the importance of implementing lasting policy directives, and how is the Bureau's recent rogue behavior harmful to consumers' access to financial services?
Thank you, Chairman. Briefly, Congress has established specific procedures that must be followed by agencies when promulgating rules. And rules are those which bind regulated parties in specific ways. And so anytime an agency departs from those specific rules, whether reflected in the Regulatory Flexibility Act, whether reflected in the Administrative Procedures Act, a lot of downstream consequences and bad results can occur. And so you're seeing where the agency departs from formal legislative rulemaking, or even departing from specifically established categories of guidance, like interpretive rules or statements of policy, and blending the distinctions. And it creates fundamental uncertainty for regulated parties in the marketplace
And
to
my time
continue
is
trying their operations.
Thank you. My time has expired, but I think it does go to show that guidance and interpretive rules should not create new obligations. You can't change the law without notice and comment or without statutory authorization. With that, I recognize the ranking member for 5 minutes.
Thank you, Mr. Chair. Attorney General Ellison, when Congress created the CFPB and the Dodd-Frank Act, it was created an independent agency which would not be funded through the annual appropriations process. Some of our witnesses and some of my colleagues on the other side of the aisle seem to want to go against the original intent of the authors of Dodd-Frank and subject the agency to the annual appropriations process. Now, you and I were in the room when the decision was made in the wake of the financial crisis to establish an independent funding mechanism for the CFPB. You remember, for example, the bipartisan incredulity at, for example, when we ask ourselves, how could the SEC possibly have missed Bernie Madoff? And the answer came back that Congress had abused the power of the purse to systematically eviscerate the SEC's capacity to find bad actors like Bernie Madoff, and people on the other end of those scamsters suffered. And the same thing applies to the toxic assets that were all based on mortgages that I think officially it was the Federal Reserve that was supposed to have been the cop on the beat to stop all these garbage mortgages from being rebundled and all that sort of, in which I think Barney Frank referred to as someone with a tremendous sense of humor put the Federal Reserve in charge of oversight of the mortgage industry. And so there's a lot of history that I think is in danger of being lost, and thank you for appearing here. So do you have any concerns about an alternative approach to funding, and what are the dangers that you'd see in
Certainly,
removing the
Mr.
insulation?
Chairman, Ranking Member Foster, the CFPB every day gets up and does things where there are folks with very powerful financial interests to try to impact what they're doing. And therefore, it makes a lot of sense to be able to have a funding mechanism that does not make them easily susceptible to administrative capture, that makes them somewhat immune from the vicissitudes of one case or another. Now, it's interesting because I think that it's simply wrong that the appropriation process is the only way Congress has to do oversight. I mean, we're having an oversight hearing on the CFPB at this very moment. Congress can change the statutory scheme for the CFPB any time that it wants to. If you can get House and the Senate and the President to sign it, then you got to change. It's set up for a reason because we know that if you subject this institution to the appropriations process, it is simply going to change from session to session, moment to moment, giving no one any clear guidance or anything to rely on. So thank you for your question. I think you're absolutely right.
Okay, let's see. Mr. Johnson, you had a rather tortured attempt to separate safety and soundness from consumer protection, right? That they were somehow fundamentally different. I think you're wrong in that. Actually, the CFPB provides a service to all actors in the financial service to protect them from competition from bad actors. All right, and that is a service that the financial system has come to depend on. Because prior to the CFPB, you know, we would I'm sure Secretary or Attorney General Ellison and I both had financial entities come into our office and complain about other sectors of the industry that were bad actors and how come we're not doing anything about that. And the CFPB was the answer. And so I think it's false. Now, actually, Mr. Watkins, you'd indicated there were many other agencies that you thought should be looked at by the courts or Congress. So prior to the CFPB, it was the Federal Reserve that was responsible for consumer protection. In your view, was that unconstitutional?
It is my view that all federal agencies, including the Federal Reserve, should go through the congressional appropriations process for their budget.
Okay, and so you believe it's perfectly fine next time Jay Powell comes in front of us, if we say, look, if you don't raise interest rates, we're going to cut your budget? You think that's a good future for the United States?
I don't think that's what Congress should do. I think it's perfectly appropriate if you think the Federal Reserve is doing a good job to give it the money that it's asking for.
Okay, and don't see any lessons from history of having a non-independent Federal Reserve. Okay, let's see, I'm nearly out of time, so I'll just yield it back.
The gentleman from Florida, Mr. Posey, is now recognized for 5 minutes.
Thank you very much, Mr. Chairman. Most citizens believe that we make all the federal laws, that all the federal laws on the books are passed by Congress. But most people in this room realize that for every law we pass, there's probably 1,000 laws that are made by unelected, unrecallable, oftentimes unaccountable bureaucrats. They're supposed to make rules and that are enforceable as laws, specifically at the direction of Congress. But Congress has abdicated its responsibility to control the rulemaking process. So the odds are, if you're called into court now on a federal violation, it's probably 1,000 to 1 odds it's against a rule enforceable as a law that some unelected bureaucrat made. When Director Kraninger, former Director Kraninger, the FPB, appeared before us on her first semi-annual report in 2019, I asked her about whether the CFPB should conduct cost-benefit analysis on its regulations. She expressed her strong support of the idea, and she held a Bureau symposium on cost-benefit analysis in 2020. Apparently, little progress was made on that front after 2020 under Director Chopra, so I'm pleased that we have 2 bills for this hearing that would institutionalize a culture of cost-benefit analysis at the CFPB. Mr. Watkins, briefly, could you explain how cost-benefit analyses could be used to improve rulemaking at the CFPB?
Sure. So as cost-benefit analysis, we look to the benefits and the harms of every rule. We try to evaluate in detail all of the various benefits and all the various harms. And if you look at that in detail, you can find areas where the harms outweigh the benefits. And so by relieving the pressure on those areas, by either not issuing rules or issuing less stringent rules, we can make the rules provide more benefits to the American consumer and at the same time cost less harm. It may be better to create a slightly less stringent rule that provides the same benefits and yet allows the industry to have more money to give to consumers or to not cost consumers as much.
Thank you. And I can't understand why they wouldn't do that, other than it's been my experience with CFPB. They're the most arrogant, petulant, and defiant agency that I've ever dealt with. Mr. Hempler, the current management of the CFPB believes that many or most of the fees and financial institutions charge are junk fees and merely made up. I don't want to call that junk regulation, but it's tempting. Please explain how many or why even most so-called junk fees represent a legitimate reflection of the economic opportunity cost of the funds tied up in the consumer credit when consumers pay late.
Thank you, Congressman. It's great to see you this morning. Essentially, the press release that the Bureau issued on junk fees, one, it goes beyond its authority to address resort fees, ticket fees, well beyond anything in the financial services arena to begin with. There's no definition of what they're talking about, and it has a chilling effect on our member companies, both depository institutions and finance companies, in terms of wanting to stay within the guardrails of what our regulator expects of us without knowing what those rules are. It's kind of like trying to figure out what the speed limit is without the sign being posted, but still held accountable. The Attorney General talked about accountability or institutions not wanting accountability. What we're trying to do here is figure out what the rules of the road are so that we can be good corporate citizens. We want to stand shoulder to shoulder with the CFPB in its mission to protect consumers. But I think the best way to protect consumers is to protect access to credit. And the best way to protect access to credit is to have clearly defined terms and conditions that both industry and the regulatory community can understand and follow.
Under Section 1022D of Dodd-Frank Act, the Bureau is required to produce a report on an assessment of each significant rule or order adopted by the CFPB under federal consumer financial law. The review is to be completed 5 years after each significant rule and is to be subject to public comment. Finding such reviews is hard. Ironically, there's an assessment that was posted on March 3rd for the Mortgage Disclosure Rule Act, which CFPB says was not a significant rule under the Act. Mr. Hempler, can you please comment on how well the CFPB is complying with Section 1022D?
With respect to the rules, I think where I would start with is actually finding the rules that the Bureau comes forward
Laws,
with,
yeah.
the regulations. These pronouncements that they put forward without giving industry any opportunity to provide notice or comment means that they're really not well informed in terms of how they're implemented.
Thank you very much. Thank you, Mr. Chairman.
Gentleman's time has expired. The chair now recognizes the gentlewoman from Ohio, Ms. Beatty, for 5 minutes. Thanks.
Thank you, Mr. Chairman, and thank you to all of our witnesses who are here today. We've certainly had a lot of discussion about this, and especially from my colleagues on the other side. So I guess I'd like to ask the first witness, can you tell me, Mr. is it Krempler? Kempler. Can you tell me if you know how many dollars are returned each year to consumers thanks to the CFPB and their great work?
I believe a total has been put out there in terms of $16 billion, but I couldn't tell you on an annual basis.
Do you think that sounds, I'll say it's 16 to 18 million, so I'll give you that. I think you're in the right range. I think that's important for us to know the work that they did. Are you familiar with the work that Mick Mulvaney or Kathleen Granger did?
Some of it.
Okay, and they continued it, appointed by the last administration, and continued to do it. So let me be clear and be on the record that I am very supportive of CFPB and the work that they've done, Democrats and Republicans, 2 Republican directors during the last watch continued it. We also know that in this country, there are things that are discriminatory. There are people who are treated with disparities. My good friend, the late John Lewis, and civil rights icon, said, if you see something that is not right, that is not fair, you have a moral obligation to do something about it. And as a member of this committee, along with many of my colleagues, I take that very seriously. And I think what the CFPB has done, whether it's for our seniors, whether it's for people who have been in abusive financial situations, they have made it all the better good. Mr. Ellison, thank you for your work. Not only in what you're doing here, but the years you invested. And you could have been off practicing law or doing some of those great things, but you stayed here. And we served together on this very committee, a committee that I've been on ever since I entered Congress. This agency, CFPB, established in the wake of a dangerously under-regulated industry that ultimately led to a national and then a global recessions, looks out for all of our constituents. In my district, in my Republican colleagues' districts, as well as trying to create fairness, transparency, and competition in our financial system. And here's where I'm going with this. I believe wholeheartedly that we have a lot of work to do, and this agency can help us, because we know that study after study will show us that there's discrimination in lending, that there's consumer abuse, that there is fraud. I even wrote an op-ed that was published in The Hill last month addressing these comments because I've had my colleagues tell me that they were tired of hearing about discrimination in lending and we should move on. So that has bothered me from the time my colleagues said that until today. So Attorney General Ellison, as part of the CBCF's mandate, is to root out unfair, deceptive, and abusive practices. The agency last year authorized that this also extends to unfair discrimination as well. Can you address the allegations that discrimination does not exist in financial services, and tell us why you think it's critical that the agency should protect our consumers to combat these harmful practices?
Well, Congresswoman, it certainly does exist, and attorneys general around the country know it, and it is very pernicious in its effects. It involves student lending, it involves mortgage lending, auto lending, and the beat goes on. And what it does is undermine the opportunity for meaningful prosperity, the American dream for women and people of color in our country. And our economy would work better if people were able to receive fair treatment. And let me just tell you, it's not only is it going on now, it's been going on for quite a long time. I'll just say that, you know, for literally hundreds of years, we've seen this disparity, and I'm glad that you're committed to rooting it out.
Thank you. My time's up, and I yield back.
The gentleman from Missouri, Mr. Lukemeyer, is now recognized for 5 minutes.
Thank you, Mr. Chairman. Just briefly, I know that the ranking member made a comment a minute ago with regards to Mr. Johnson's testimony saying he was tortured. I have a question with regards to calling the CFPB a service organization. I think that's a torture definition of the CFPB. Mr. Johnson, you work there. Would you call the CFPB a service organization?
Well, what I meant to express was that the CFPB's fundamental mission is to supervise institutions and enforce a discrete set of laws and rules that are assigned to it by Congress.
So it's an enforcement organization, basically.
Right, and there are many market conduct regulators, like, for instance, the SEC, the FTC, the CFTC, the Consumer Product Safety Commission, whose fundamental mission is to enforce a discrete set of laws.
Thank you.
They regulate market conduct, and they're all appropriated.
Thank you. Along that line, I'd also like to, Mr. Johnson, you work there, you're an attorney. You saw the funding mechanism that is in place right now, and I read to you out of Dodd-Frank, Section 1017, Funding Penalties and Fines. It says, "The Board of Governors shall transfer to the Bureau from the combined earnings of the Federal Reserve System the amount determined by the Director to be reasonably necessary to carry out the authorities of the Bureau." In our hearing yesterday with the Fed Chairman, Chairman Powell, he admitted, because of the structure of his assets right now, he is losing money at the Fed. There are no earnings. And in fact, I asked him, how are you going to pay your bills? He said, we just print the money. And so I asked him the question then, how are you going to pay the bill that's presented to you from the CFPB? And his answer was, we'll print the money. So my answer to you is, the law says it's supposed to be paid out of earnings. If there are no earnings, can the Fed pay the CFPB bills with money it prints?
Well, I understand that there's a bill to clarify whether or not it can do that. As a
I'm
fundamental
asking whether there's a
matter,
bill to do that, Mr. Johnson. I'm asking, can they legally at this point in time, with no earnings, pay the bills of the CFPB?
I'd say an average American finds it difficult to pay bills with no earnings. I think the Fed's accounting treatment maintains negative balances.
Thank you very much for that. One of the concerns of, is the CFPB has no authority over overdrafts, do they, Mr. Hempler?
They have no authority
They
over.
have no overdrafts. They have no authority over the description of service fees on a hotel bill, do they?
No.
And yet, now they've created this word called junk fees. Ms. Thompson, is there such a word, prior to their creating this word, is there such a word as junk fees in financial lexicon at this point, prior to this?
Maybe perhaps in the popular Rubicon and language, but not in
There is not a
the
defined,
enforcement
there is
authority.
not a definition
Yes,
of junk fees in the financial lexicon like there would be for annual percentage, annual percentage rate, right? Okay.
Correct.
So what we've done here is have a director who, because he has no authority over these things, create a word. And then he twists his UDAP authority to be able to say, well, now we've got this situation where we have junk fees out here that we need to have somebody regulate these things. And now he has authority because he's twisted UDAP to be able to fall under junk fees, which he has no authority because there's nothing there to provide oversight. Is that a pretty fair statement, you think, Ms. Thompson?
I would agree.
So the fact that we now call them junk fees doesn't mean it's real, because there is no such word out there, and there is no such authority. So I think we as a group need to be pushing back. All of you here this morning need to be pushing back. Ms. Templer.
Thank you, Mr. Lukemire. Directly on your point, the fact that there is no definition leaves financial institutions, both depositories and finance companies, with no roadmap as to how to follow that. I mean, like I mentioned, he calls into question resort fees and ticket fees, but also calls into question credit insurance that's tied to the underlying contract with the consumer. That very insurance product helped out millions of Americans that were facing flooding situations down in Louisiana just a couple of years ago.
I thank you for that. I know that yesterday in one of the political magazines here, they had a long expose on the CFPB as a result of this ruling. And they're talking here about the legal uncertainty that could undermine the CFPB as a result of this coming decision. It could put also their other rules in jeopardy. Mr. Watkins, do you see that happening?
I do think there is a possibility as they kind of expand their definition, things like junk fees, where I think the definition they seem to be working with is any fee they don't like. And when the definition under how they're acting is so broad like that, it raises real non-delegation concerns that could undermine their authority to enact any of these.
Thank you very much. My time is up. I yield back.
The gentlewoman from California, Ms. Waters, is recognized for 5 minutes.
Thank you very much, Mr. Loudermilk. I'm going to break protocol here for a minute and just say I'd like to welcome Mr. Ellison. I'm so excited to see him. He served on this committee, and he's considered one of the most respected and capable attorney generals in the country. Thank you very much. Okay, now, if I can just calm down a little bit. Attorney General Ellison, last year, the CFPB launched an initiative to combat junk fees, which has the potential to save consumers billions of dollars each year. The CFPB's work is really resonating with consumers as they received more than 50,000 complaint letters on this initiative. It builds on the work of this committee during my time as chair to combat excessive overdraft and other fees that really make it difficult for consumers to save money. I understand that in 2021 you led a bipartisan coalition of 33 attorneys generals to oppose an agreement that would have allowed the mortgage servicer, that is PHH, to continue charging illegal payment processing fees. Members on the other side of the aisle apparently think the CFPB lacks authority to combat junk fees like this. Do you think that the CFPB has the authority to combat junk fees? If so, do you think they should use their tools to combat excessive payment processing junk fees?
Madam Ranking Member, let me express my appreciation for being invited here today. It's really, really wonderful to be back. Regarding junk fees, maybe certain firms don't know what junk fees are, but consumers do. Consumers know what a junk fee is. It's a fee that when you signed up for the service or you engaged the company, they didn't disclose it, they didn't tell you about it, you didn't know, you didn't have any reason to anticipate it. It's a fee that they tack on because they have the market power to impose that fee. We enforce this not only in the financial services area, but in a lot of areas. So, for example, in the internet service fees, I mean, when a company, Comcast, whatever, Frontier, they tell consumers, hey, this is it's Thursday fee, and you got to pay it, and if you don't, we're going to cut you off. These are the kind of fees that are unfair. There's not proper notice often. If it is, it's buried deep in the small print. And it is absolutely appropriate for the CFPB to regulate this. I can tell you attorneys general, both Democrat and Republican, do it every day. And it is part of the way that we create confidence, faith, and create the ability for consumers to have a shot at prosperity. So I think it's entirely appropriate for the CFPB to do this work.
Thank you, Mr. Ellison. Last year, the CFPB issued an interpretive rule which reaffirms states' authority to initiate enforcement actions based upon violations of federal and state consumer financial protection statutes. In your testimony, you state that CFPB has been a critical partner in the enforcement efforts by states, including Minnesota's, to stop these actors in the area of student debt relief. How was CFPB helpful in terms of halting student debt relief fraud?
Well, thank you for the question, Congresswoman Waters. I noted that one of the cases that we brought in October 2019 was with North Carolina and the city of Los Angeles when we sued a series of companies and individuals running a fraudulent student loan relief scheme that falsely promised to help people pay off their student loans and obtain student loan forgiveness in the process. The CFPB has been an indispensable partner in helping working and middle-class people pay their bills. And I would add that a lot of small businesses look a lot like consumers. So it's not only your typical consumer that the CFPB helps. They help the entire market, as I think Congressman Foster already noted, by creating market stability, sending proper signals. And as you have noted, Bernie Madoff in his kind of behavior, did more to damage consumer confidence than any regulatory agency. I mean, it is the bad actors that undermine market stability, not regulators that are trying to protect consumers. So I thank you for your question.
And thank you so very much. I yield back the balance of my time.
Gentleman is yielded back. The gentleman from Texas, Mr. Williams, is now recognized for 5 minutes.
Thank you, Mr. Chair, and I'm listening to all the testimony today, and I can't believe how many people in this room know about the car industry. It's just pretty amazing. Full disclosure, I'm a car dealer. I know about this stuff. I'm probably the only person in this room that has confrontation with Operation Choke Point. I can tell you these people are not fair, and some not good people in this, that deal with this, and I'm listening to student loans, and I thought we didn't want the people to pay their student loans back. I thought that was the issue. So with all that being said, talk about junk fees too. I thought junk fees were taken care of in the Obama administration. So the CFPB has a history of neglecting the interests of small businesses by creating burdensome regulations and evading the traditional rulemaking process. And as a small business owner, as I said, a car dealer, one who offers credit, I can tell you that certainty is the key. Businesses need to know the rules of the road before they are hit with arbitrary enforcement actions, making their operations more difficult. And last December, for example, I asked Director Chopra how his agency had been working to accommodate the concerns of small businesses within the CFPB's rulemaking process. He responded with the intention of improving the process by March, and here we are 2 weeks into March, and I have only seen the opposite as the CFPB continues to ignore the concerns from the private sector and small business. So, Mr. Hempler, with your industry experience, have financial institutions experienced increased compliance costs from regulations or enforcement actions, number one, and can you elaborate on the effects these costs and regulations have on small businesses?
Thank you, Congressman. Your statement was right on the money. It has a chilling effect on overall industry. The compliance costs of trying to chase after phantom regulations, junk fees, there's no definition. If there is something that the director wants to root out, we're happy to work with them in a notice and comment process that allows input from affected industries. But ultimately, the impact is ultimately on the consumer. And what it has is a chilling effect, and what it will do is essentially limit access to credit, and that's in nobody's best interest.
Well, exactly, and banks have to hire more compliance officers. I'm in the car business. I have to hire a compliance officer, and everybody in my business is on commission, for crying out loud. So how do you pay a compliance officer on commission? Somebody needs to tell me that. So secondly, the CFPB was created with primary goal of protecting consumers from the abusive financial practices. However, unlike other federal agencies, the CFPB was designed to operate outside of Congress's annual appropriation process, as we've talked about, shielding them from an agency oversight and accountability. Now, the CFPB's ability to make rules, enforce those rules, and adjudicate disputes gives them the power to act as a prosecutor, judge, and jury. This concentration of power in one agency raises concerns from a lot of people. It's an abuse of authority and the violation of due process rights for individuals and businesses. And I'm glad to see that this has been a priority of the Financial Services Committee, this Congress, to take action against the CFPB. So, Ms. Thompson, how does the lack of accountability for the CFPB hurt the interests of the American public? And how would funding the CFPB through congressional appropriations benefit consumers and increase transparency?
The people's representatives are here in Congress, and without the appropriations process, CFPB is free to abuse its vast regulatory powers, which include adjudicatory, rulemaking, and enforcement actions. Bringing the CFPB into the appropriations process would ensure accountability not only to the members of Congress, but to the American people and the representatives that they've elected.
Thank you. Now, a brief time I have, when I talk to community bankers back home in my great state of Texas and my constituents, every person tells me how terrified they are about the CFPB's 1071 small business data collection rulemaking. They're concerned that the rule will push the industry towards standardized small business loan product and kill relationship banking, community banking, and that bank employees will be forced to consider factors outside of creditworthiness when reviewing small business loan applications. And last year, the SBA Office of Advocacy even stated this, that they're concerned that the CFPB's approach may be unnecessarily burdensome to small entities, may impact the cost for credit for small businesses, and may lead to a decrease in lending to small minority and women-owned businesses. So quickly, Mr. Hempler, can you expand on the potential problems with 1071 data collection?
If I can give you just one example, Congressman, I know this is an area that's near and dear to the ranking member's heart, that you worked on this in Dodd-Frank, but just in the auto finance space, our industry is governed by both the Fed and the CFPB, and there's incongruity there, and they're promulgating a rule that doesn't mesh up.
Gentleman's time has expired. The gentleman from New York, Mr. Meeks, is now recognized for 5 minutes.
Thank you, Mr. Chair, and I'm just listening, You know, and I hear you, Mr. Hempler, saying that, and I've worked with you and your organization, and I appreciate what you do in that regards.
Thank you.
And I think that we need to find out, you know, so that we can continue to work together. But you keep saying access to credit, which is very important. But the CFPB was put in place to make sure that it was fair access to credit. Because what happened in the financial crises, they got access to credit. That also made them lose all their wealth because they were taken advantage of. There was fraud, and that's why it was created. So it wasn't just about access to credit. It was access to fair credit so that individuals would have an opportunity to buy a home so that they could do what others, create wealth, and as a result of not having fair credit and not having consumers a voice to say this is a divisive piece that will take away your wealth, we said that there had to be a voice for consumers. And so I appreciate everybody on this panel, but there's only one person that I've listened to that has a voice for consumers. It's called the Attorney General. And do you know why we have Attorney Generals in this country? Because the people need a voice separate from others. That's what we need. And what we realized here in Congress, after the financial crisis, nobody spoke for the people. Nobody. And that's why 80% of the people want the Consumer Financial Protection Bureau, because they want a voice also. Mr. Watkins said something about subject to the king. Well, the reason why the founders of this country left because they didn't want to be subject to the king, because the people had no voice to give the people a voice. Well, guess what? We want to give the people a voice. We don't want to be subject to the king. The people must have a voice, and that voice is the CFPB. And what I've heard from everybody thus far, it's not about reforming. It's about getting rid of, diluting, changing. Not for the benefit of the consumer, for sure. It's for others. So you've got to right the ship. And that's why the CFPB is so important. And you can't say, now, because you're not part of that voice, everybody else has different responsibilities, but I want to write the rules for them. No, that's subject to the king. That's what the king used to do. The king would set the rules for the people, and the people had nobody to speak for them. And so we set up a government, so we have an attorney general to speak for the people. And when we got here and we saw, because when we see all of these things that's going on, the ones that was getting ripped off were people, the average everyday American. Your constituents and mine, my Republican constituents and mine getting ripped off, rural and urban, every part of this country, nobody escaped. So we said in the conference, because that's what Congress is supposed to do, and its infinite was, well, let's get a voice for the people that can look and on this and make something and give an example. And that's why this is so important. Not ending the people's voice. Let the people have a voice. Let there be some decisions. You know, so many people in my district, I'm a big advocate of home ownership. I said that's the way to wealth, to create wealth for everybody. And we know that that hasn't been fair. We know that especially in minority communities or in black communities, redlining took place, interest rates were always different. It was not fair. In fact, some would love to give you access to credit so they can make more money and charging the higher fees to these individuals. They need a voice. So we should be talking about what we could do to help strengthen the CFPB. That's reforming it so that the people have a stronger and louder voice. That's what you do, Mr. Attorney General. Is that not right? Don't you protect the people in the state of Minnesota?
Every single day. And I work with your Attorney General to help folks in New York, and your Attorney General to help folks in California and Ohio and all over the country.
And Republican Attorney Generals?
Absolutely. We work in a bipartisan way.
That's what this is all about. So we're really talking about the CFPB. Let's talk about how we strengthen it and make sure that the consumers have a voice. I yield back the balance of my time.
The gentleman yields back. The chair now recognizes himself for 5 minutes for questioning. It's an interesting dialogue we're having. Thank you all for being here. I partially agree with my colleague, Mr. Meeks, in his comments about the king. The issue we're really here is defining who is the king. Kings have ultimate authority without any constraint, without any oversight. And I think what we're saying here is the CFPB is becoming the king. It was brought up earlier also that if Congress wants to change the CFPB, then it just needs to change the law. However, Mr. Johnson, as you point out in your testimony, the CFPB has a long track record of dodging or outright defying statutory limits on its authorities. Thus, why the framers of our Constitution gave Congress the power of the purse to ensure that the executive branch stays within the statutory limits that's given. One of my many frustrations with the Bureau has been its historically expansive view of its own authority, oftentimes in conflict with congressional intent, legal precedent, and administrative procedures. For example, last year CFPB claimed that it can apply for UDAP credit discrimination, or can apply UDAP credit discrimination laws to any decision-making by a financial institution, including deposit and payment functions. Mr. Johnson, does the Bureau have the authority to broadly interpret and apply the law in this way?
Thank you, Congressman. So Justice Scalia once said that Congress doesn't hide elephants in mouse holes. And the Supreme Court has recently spoken to the major questions doctrine, which says that an expansion of authority requires an express grant of authority in statute from Congress. And it may be that what the Bureau is proposing to do is eminently wise, but there's a method and a process that it needs to follow to do so. And what it is proposing is an interpretation of UDAP authority that contradicts 80 years of settled understanding, going back to the grant of original unfairness authority to the FTC. And I think there was probably no discussion whatsoever during deliberations, at least reflected in the legislative record, that unfairness or UDAP authority could reach the type of conduct that the Bureau is trying to reach. I think this is fundamentally a decision for Congress to make, and if it wishes to expand the CFPB's authority based off of the arguments that it raises or the necessity in terms of the conduct it observes in the marketplace, that's a decision fundamentally for Congress.
Well, thank you for that. And aside from falling outside the strong congressional oversight through appropriations process, one of the reasons that the CFPB is so troubled is because its single director governance structure makes it more susceptible to dramatic policy shifts depending on the political alignment of the director. For example, due to significant regulatory uncertainty, many banks have withdrawn from the small dollar consumer lending. Can you discuss how a multi-member board would bring regulatory stability?
Sure. So fundamentally, in the consideration of significantly complex questions in terms of the operation of a regulation and the downstream effects and perhaps consideration of the unintended consequences, I think it's entirely foreseeable that the inclusion of the views, the opinions, the experiences of multiple members could help the agency arrive ultimately at a better conclusion. That said, I would say that it's not a guarantee that that's the case, and there are folks who are observing, government agencies today that are multi-member commissions that believe that, the agenda is not hampered by the presence of minority members of a commission.
Thank you. Mr. Watkins, the CFPB strategy seems to be use every means available except the formal rulemaking process to regulate the financial industry. For example, like many other agencies, the Bureau issues circulars that are meant to provide clarity to the industry. However, many of these CFPB circulars do not provide clarity at all. Instead, they set forth disturbing expansions of CFPB authority, all without clear congressional authorization or the opportunity for public comment. What implication does this kind of regulation have for public policy and the rule of law?
Well, it really undermines the rule of law. The rule of law is based on the foundation that the rules of society, the conduct that people are supposed to follow, are well known so that they can maintain within that boundary and make sure that all their actions that they do follow the rule of law so that they don't get punished, and only the bad actors that violate those rules get punished. But when the agency acts as like it has, it undermines the rule of law by blurring that line so that people can't tell if their actions are unlawful or not until it comes before the agency, in which you're like, I don't know if what I did was lawful or not, because you haven't clarified that. And so the way that it does is really undermines accountability and people's ability to follow the law.
Thank you. My time has expired, and the gentleman recognizes the gentleman from Illinois, Mr. Caston, now for 5 minutes.
Thank you so much. Appreciate you all coming here today. So I want to just do a dumb question first. There's a lot of talk about whether the, given what's going on in the court right now with the funding structure of the CFPB, just show of hands, how many of you are funded through congressional appropriations? How many of you would like to be funded through congressional appropriations? How many think you could do your job better if you were funded through congressional? All right. I thought we might end up there. Mr. Ellison, it's nice to see you here. I know not that long ago, you were sitting on the other side of the dais in this committee, and appreciate your service.
Thank you.
I wonder, when you were here and the work that you did to look after our financial institutions, did you feel like you were struggling to understand the needs of our banks and our financial community, that their lack of congressional funding for appropriations limited their ability to communicate with you and make sure you understood their needs?
Oh, no, they beat a path to my office every day. They were very well represented.
So, to be less cute, you were also here before and after the creation of the CFPB. How did the creation of that institution affect your ability to understand the needs of consumers and customers and borrowers and the people who ultimately are the money that drives our financial sector?
Well, one thing, Congressman, is that it gave me, as a person trying to provide constituent services, a clear place to help consumers to go. Because before the CFPB, and the chairwoman will my chairwoman will recognize that there were a whole bunch of different federal agencies that had the responsibility. And of course, if everybody's responsible for something, then really nobody is. And so you got consumers who could go to a clear place and get clear answers and really get some real relief within a reasonable amount of time. And now that I've been Attorney General, the CFPB is an excellent partner. And is also an advocate on a range of things when it comes to sharing information, helping consumers to understand what they're facing. The work that you all do on this committee is complicated. It's not intuitive. You have to study it. And for a consumer who's just trying to get a loan for this or that, they don't read all the fine print like you all do. But the CFPB does. And so they're just this indispensable partner, who I think really does help the American family meet their financial obligations and reach their dreams. And I think you've got to have an advocate like the CFPB.
But I wonder if you're comfortable speaking for our state's attorneys general. We have these numbers of $16 billion returned. That doesn't happen if they're there. What has that meant for the resources that you have and how you can do the job of the people?
Well, it means that I can speak with some authority because I do talk to my colleagues all the time. Obviously, they are all very capable of speaking for themselves. But, in the AG world, and there is one, we meet, we talk on a whole range of things. It might be anything from opioids on the one hand to student loans and payday lenders on the other. And I can tell you that we have our own partisan wrangling that we do. But as a person who has been in this body in Congress and now I'm in the AG world, there's no comparison. We work together on a far better basis. So many of these national multi-district cases have Republicans and Democrats together. So I hope that
I want to
answers-
just read you all a quote here. Civil government, so far as it is instituted for the security of property, is in reality instituted for the defense of the rich against the poor, or against those who have some property against those who have none at all. Anybody know who said that? It's Adam Smith, Wealth of Nations. So much of our job here is to make sure that if we believe in capitalism and innovation and all that happens, is making sure that everybody has a voice. And, we voted a few weeks ago to condemn socialism in all its forms in the House floor. And let's hear it for that, and let's read the foundational text. Thank you. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from South Carolina, Mr. Timmons, for 5 minutes.
Thank you, Mr. Chairman. The CFPB was created to, quote, make consumer financial markets work for consumers, responsible providers, and the economy as a whole, end quote. Since that time, the CFPB has clearly strayed far from that mandate. Court case after court case, many of which are worthy of review by the Supreme Court, regulation by enforcement action, consent order, press releases, and even conference speeches by the director, all carried out under the problematic umbrella of the CFPB's insulation from congressional oversight and basic checks and balances. What is not at a loss in this hearing today is the understanding that a rabid, out-of-control CFPB only harms consumers. After reading all of your testimonies, what I heard loud and clear is that the CFPB has strayed far from its mandate and no longer works for the economy, responsible providers, and most importantly, consumers. Mr. Chairman, I look forward to working with my colleagues on the subcommittee to rein in the CFPB and maybe sooner rather than later work to reshape the CFPB into an accountable and effective agency that works to empower consumers, not hold them back. Mr. Hempler, I'm going to start with you. The CFPB has rolled out several new enforcement mechanisms over the last 2 years: proposed rules, final rules, UDAP authority expansion, advisory opinions, supervisory opinions. We keep going. Enforcement by press release. These are all just some of the tactics that allow the Bureau to weaponize dormant statutes and regulations outside of APA rulemaking. Industry has been forced to greatly increase their compliance costs while the consumer has seen no real benefit. In fact, over the last 2 years, we've seen costs for almost all services go up to record levels. Can you talk about how these actions have harmed consumers in the form of increased costs of housing, financial services, et cetera, and I think more importantly, also hampered industry's ability to innovate as they focus on complying with what's clearly an out-of-control CFPB?
Thank you, Congressman. My head was almost spinning with the laundry list of things that you've just mentioned. I'll go back to my oral statement. We like what the director has actually said, at least in one regard. He said that markets work best when rules are easy to understand and easy to enforce. We couldn't agree with him more. But what we have in terms of press releases and blogs, it's like being on I-95 and you're supposed to follow the speed limit. But the speed limit is being set by somebody who's just issued a press release or just made held a press conference or speaking at a conference or anything like. You don't know what the speed limit is, but at the same time, you're accountable. That has a chilling effect. It causes increased costs in terms of just trying to chase after compliance to hundreds of times of where it's been in the past. And ultimately, those resources that could go to increase access to credit are relinquished to following after these ghosts.
Sure. Businesses just want predictability. They want stability. They don't want to be guessing what they're supposed to do. And I think part of this is going to be a leadership issue and examining how we appoint the director or the leadership structure entirely. So that's the next question I have.
Congressman, can I comment to that? I don't think anyone here at this panel has testified today for doing away with the CFPB. All right? The CFPB's mission is an important mission, but at the same time, we need accountability, and that's what the witnesses that share the panel with me.
Absolutely. I mean, the broad authority and unchecked power of the CFPB, particularly its single director leadership structure, is alarming and has had a clear negative impact on the consumer financial services ecosystem. I know my colleagues across the aisle appreciate the work being done by the current director, but it wasn't too long ago we had a Director Mulvaney, and I don't think they appreciated the way that he went on about his job. So, Mr. Johnson, what are some key legislative solutions that Congress should consider to ensure the CFPB abides by the system of checks and balances?
Thank you, Congressman. So I had testified about the importance of congressional appropriations as being a measure that can ensure that the agency's priorities are aligned with those of your constituents and the collective needs and interests of the American people as understood by Congress. So that's one. In terms of internal checks and balances, as you may know, the CFPB doesn't have its own independent inspector general. It shares one with the Federal Reserve. That's a consequence, I think, of the funding structure itself and housing the CFPB within the Federal Reserve System. If the CFPB had an independent inspector general, I think the oversight that can be provided through audits by an inspector general can help appropriately tailor and focus the agency's mission to align it with its statutory responsibilities.
I'm running out of time. I appreciate your answer. I think we're going to have an opportunity here in the near future to reform the CFPB. I look forward to working with my colleagues on that.
The gentleman's time has expired. The chair now recognizes the gentlewoman from Massachusetts, Mrs. Presley, for 5 minutes.
Thank you so much, Mr. Chair. In today's hearing on the Consumer Financial Protection Bureau, we should really be praising the work of the agency and discussing how to augment its successes for consumers all across our country. I want to thank you, Attorney General Ellison, for joining us today and for doing exactly that. Without question, under Director Chopra's leadership, the agency has taken action on junk fees, medical debt, appraisal equity, and held bad actors accountable for their greed, exploitation, and illegal behavior. Unfortunately, colleagues across the aisle are busy trying to criticize the agency and to undermine its mission. There's a particular case that CFPB brought that has been raised in this hearing, and the primary focus of legal arguments, it is the lawsuit against Townstone Financial in Chicago. And Ms. Thompson, you are here on behalf of Pacific Legal Foundation, which represented Townstone Financial, correct?
Yes, ma'am.
And according to your testimony, the origins of CFPB's suit was regarding redlining. For the record, since there's been a lot of banter today about definitions, what is the precise definition of redlining?
The CFPB does not have a precise definition of redlining.
I'll elucidate you as to the definition. According to the Legal Information Institute, redlining is a discriminatory practice that consists of the systematic denial of services, such as mortgages, insurance loans, and other financial services to residents of certain areas based on their race or ethnicity. And the history of the term dates back decades to when lenders would literally draw a red line around neighborhoods to stop black people from moving in as a way to maintain segregation. Today, this practice is not as overt, but it still persists. And again, not as overt since the passage of the civil rights legislation. So instead of a map and a red marker, discriminatory lenders often discourage applicants by using racially coded language. Ms. Thompson, before I go further, can you confirm that Townstone used marketing services through radio ads and a weekly radio show? Yes or no?
Yes, Townstone marketed through.
Claiming my time. On the radio, Townstone repeatedly disparaged black neighborhoods in Chicago. Now, while I don't have enough time to go through all of their statements, I will share a couple for the record. The mortgage company described the south side of Chicago between Friday and Monday as, quote, hoodlum weekend. On another occasion, Townstone described a grocery store in a black neighborhood as a jungle. I can't even call these dog whistles because they are as blaring as a bullhorn. These racist messages were loud and clear for everyone to hear, and it bore out in the data. And a city as racially diverse as Chicago, where 30% of the population is black, only 1.4% of Townstone loan applicants were black, and less than 1% of applications were for properties in black neighborhoods. This is modern-day redlining, plain and simple, and that is why the CFPB brought the lawsuit against Townstone. Now, today I have the honor of representing Massachusetts in the House of Representatives, but I was raised in Chicago. I know the city well, and I, for one, am glad the agency took action against discriminatory lending practices. We need more, not less, of the CFPB. On a final note, I want to address the suggestion the agency is rooted in political bias. Ms. Thompson, who was the president in 2019 when CFPB brought that lawsuit against Townstone?
That was President Trump.
And if you don't know who the deputy director of the CFPB was when the lawsuit was filed, I'll give you a hint. It's a Republican witness sitting 2 seats down from you, Mr. Brian Johnson.
May I correct the record, Congresswoman? I departed the Bureau in March 6th of 2020.
Claiming my time. Again, Donald J. Trump was the president, and there's no political bias happening here. The agency is doing what they're supposed to do, which is to center consumers from across this country. Attorney General Keith Ellison, in these final moments, I want to give you a chance to add or correct anything for the record that has been previously stated.
I'll make a few notes. First of all, I want to thank you for laying out the record on Townstone. That was brilliant and important for the record. I think that there is more than ample oversight of the CFPB, 2 annual presentations by the leader of that institution, report requirements, a number of appearances. When I was on the committee that you're on now, ma'am, we heard from them all the time. That is oversight. And this idea that they're unaccountable, it makes no sense. We're having accountability right this second.
The time of the gentleladies has expired. The gentleman from South Carolina, Mr. Norman, is now recognized for 5 minutes.
Chairman, Ms. Thompson, you want to respond to that? I yield.
I appreciate the opportunity to respond to that. Representing Townstone and Mr. Sterner, I have had the opportunity to listen to the radio shows that were involved in the CFPB's complaint against Townstone, unlike many others who have reviewed the complaint. Listening to those shows, I can tell you all that Townstone never discriminated against any applicants for credit. Townstone never said racially derogatory statements to any prospective applicants. What is really going on here is that CFPB is trying to be the police of free speech, and any speech that it disagrees with on a viewpoint and content basis, and that is against the First Amendment. They cannot censor creditor speech.
Thank you, Ms. Thompson. I want to thank all the panelists. If there's ever an agency that ought to be zeroed out, it's the CFPB. I was on the bank board for a number of years, and it's a rogue organization. Now, the funding has been mentioned. The budget in this past year was $717 million. There's 1,500 people that are employed by the CFPB. If you ink that out, it's $478,000 per employee. $478,000. Now, I know that's for some for overhead, but this agency, I can't tell you the banks, and there are over 18,000 lending institutions all over the country. But hearing my other side, everybody's a victim and everybody's being defrauded like Bernie Madoff. I'm sorry. Banks have to compete. And I didn't realize we had so many experts that could qualify fees as junk fees. I think banks compete. I think banks have shareholders. I think banks have to make a profit for the shareholders. And it's almost laughable, some of the comments being made here. Mr. Watson, your comment about jury trial. Everybody deserves a jury trial. A good example of government gone rogue is the January 6 people that are held without a trial, without being able to defend themselves, hire an attorney. And I think, Mr. Hempler, you mentioned the CFPB was doing away with arbitration.
Yes, it did.
Doing away with arbitration. I'm a real estate developer. You know how many times we've used arbitration? You get two unbiased parties, you have a mediator. You pay for that. You decide, I don't know there's anything more American than, or more the rights of the two parties. Why in the world would they have the audacity to do away with arbitration?
Congressman, great point. I'll reiterate for the record that the CFPB put forward a rule to essentially ban arbitration despite the fact that its own agency put forward a study that showed the benefits to consumers of arbitration. Congress overturned that through the Congressional Review Act, and the CFPB is trying to get around that by having our member companies have to register with a database when we use arbitration clauses. That's going to work against the consumer's best interest, and that type of end around congressional intent, both in the first instance as well as trying to end run around congressional review ban on that rule. That, to me, is the definition of unaccountable.
And it is unaccountable. And, you know, the fact that the Jerome Powell, on the funding end of it, on paying for out of profits, which there are none, Jerome Powell didn't have a clue. They get 12%. There's no incentive, and I think in 2011 with Dodd-Frank, it started at 10%. There's no incentive to come under the 12% of some imaginary number. The businesses or families' budgets could never do this, could not operate like this. Ms. Thompson, what would be the cost legal fees associated with bringing an action against a CFPB? Not everybody can do this. Would you agree?
Absolutely, and Pacific Legal was able to help Townstone with pro bono legal services, but for other entities that are engaged in legal fights with the CFPB, it can cost hundreds of thousands of dollars, if not millions.
So the consumers, they say they're helping, there's actually taking rights away. Y'all have given me a great idea to try to get this agency nixed out, and I appreciate your testimony. And every closing I've done, they've listed every fee that I have to pay for. I've never seen one hidden. I yield back.
Gentleman yields back, and the gentleman from California, Mr. Vargas, is now recognized.
Thank you very much, Mr. Chairman. First of all, I want to apologize. I wasn't here for a lot of the testimony. We had Capital Markets Subcommittee, unfortunately, meeting at exactly the same time. There was some discussion about the king. I just want to make sure that I'm on the record. I definitely believe in the king, that king. But anyway, I never want to be embarrassed of loving Jesus. I want to make sure that first and foremost. There was also a comment made about Mr. Mulvaney, Mr. Mick Mulvaney. He was a colleague of ours. I don't think that there's anybody more eminently principled than he is. He's an incredibly principled person. You may disagree with him, but incredibly principled person who's a friend to many of us, including Mr. Ellison, and it's great to see you. But anyway, you know, it is interesting. I've been around here now for a while. It's my 11th year. When I first got here, I'd love to say that the Dodd-Frank was the boogeyman, and a good friend of ours, Sean Duffy, I should say Congressman Sean Duffy, used to yell and scream and be so theatrical on how this was going to be the end of banking and finance. I loved it when it was his turn because I knew he was going to put on a good show. But, you know, that kind of waned and petered out after a while because found out from the banks that, in fact, Dodd-Frank was very helpful, especially when it had a real stress test, which was this pandemic. And the bankers came before us, and we asked them, was it helpful? They said, yeah. Yeah, actually, Dodd-Frank was helpful. Now, to be fair to them, there were a few things that they didn't like. So then, now my colleagues on the other side, and not on the other side, some are on this side now, Mr. Hugels. How are you doing, sir? And now they're after the CFPB. But it's kind of waning, too, with the exception of maybe Mr. Norman, who's a terrific guy. But everybody else is kind of, you know, and the reason for that is quite simple. You know, they've returned $16 billion to U.S. consumers, answered over 47 million questions from U.S. consumers, and they've basically been doing a pretty good job. So now it's, you know, well, should we have a board as opposed to a single director or something like that, or trim back their amount of money that they have? But it just doesn't seem that the heart's in it anymore. Now it's ESG. I think that's going to be the next big boogeyman. But Attorney General, first of all, it's great to see you.
Likewise.
My
Thank
friend.
You. Good to see you, my friend.
So you were asked earlier about the CFPB and what would happen if we didn't have it. What would happen if we didn't have it?
Well, I think that most actors in the financial services world would try to do the right thing. Most would. But then what would happen is you'd have some that didn't. Without any regulation, without pulling them back in, other industry players would have to replicate them or would begin to lose market share, and then you'd begin to see bad practices predominate. You'd clearly see, you know, you'd see foreclosures, you'd see defaults, you'd see all kinds of problems like that among consumers, which would, I think, have a cascading effect and would land us right back where we were in 2007 7 and 8, and you'll recall, first it was Bear Stearns, then it was Lehman Brothers, then it was Fannie and Freddie, then it was a mess. And so I think that, look, nobody likes regulation, but it's one of those things that we need in order to keep a financial system that is stable. And so that's what I think would happen.
No, I think you're right. In fact, I think it's working fairly well. I think that's one of the reasons that, you hear complaints, but, even, Mr. Hempler, I think I heard you right. You're not saying do away with CFPB. You're saying, you got to reel it in a bit. I'll give you the opportunity to speak.
Thank you very much. It's great to see you, Congressman.
Likewise, great to see you,
I'd like
sir.
to agree with the Attorney General. We're for regulation. That's the problem. Right now, the CFPB is being governed by press release, lack of definition. This Congress, previous Congresses enacted APA rulemaking authority. It's there for a reason. Engaging with all the stakeholders and producing a meaningful and lasting result that provide great guideposts down the road in terms of financial services. That's what we're asking for.
I understand that, but even some of their guides, I think, is to give the companies an opportunity before they get in trouble to make sure that they're doing the right thing. But my time's almost over, so I yield back the last 10 seconds, sir.
The gentleman yields. The gentlewoman from California, Mrs. Kim, is now recognized.
Thank you, Chairman. I want to thank all the witnesses for being with us today. I'm concerned about the proposals under CFPB Director Chopra, because his proposed rules will increase costs and reduce access to capital, especially to women-owned and minority-owned businesses and many families. So I want to talk about, as an example, the proposed rule under Section 1071, because that would direct the lenders to guesstimate. A small businesses owner rates based on the, on visual observation if they opt not to report it voluntarily, which you know very well. So I wanted to ask you, Mr. Hempler, what are the most urgent policy issues the CFPB should be taking into account as they, work on the final Section 1071 rule? Because we want to avoid reducing credit for women-owned and minority-owned businesses.
Thank you, Congresswoman. This is critically important. The vehicle finance industry is a key part of the economy. The auto market is another key part. And what we have right now is a regulation that's put forward by the CFPB to collect this data. By and large, my member companies don't know whether or not these folks are minority or women-owned businesses and the like. That's largely data that's available to the dealers, all right? And then our members get the contract. The Fed has not put forward a similar rule so that the two can be married up. And so at the end of the day, the CFPB is insisting on going forward with a rule that we can't implement until the Federal Reserve acts, and I think that's going to create chaos in the industry.
Let me now talk about the Bureau's new credit card late fee proposal that claims to help some credit card customers to avoid higher fees. But in reality, I think CFPB also acknowledged that in the proposal, the customers who do not pay their late fees, primarily about 78, 70, 80%, those Americans with credit cards, they will not benefit from the reduced fees, and they could, in fact, face higher costs, right? Maintenance fees, lower rewards, or even high interest paying accounts. So I'm concerned that CFPB is breaking with prior precedent by not allowing its obligations under the SUBRIFA. The SUBRIFA panels allow regulatory agencies to understand the cost that proposed rules may have on small businesses. So in that proposed credit card late fee rule, the CFPB certified that we would not have a, quote, significant impact on a substantial number of small banks and credit unions, end quote. So I want to direct this question to you, Mr. Johnson. Based on your experience, does the CFPB have a process in place to officially certify the rules that do not have a disparate impact on small businesses and small banks? And how do you think that the CFPB reached the conclusion to waive that SUBRIFA requirement?
So I don't know, Congresswoman, how they reached that conclusion. The analysis in the CFPB's proposed rule was perfunctory. It's a statutory requirement to, consider whether or not there would have an effect here. I do think, putting on my old agency hat, that the Bureau really has real risk with this rule. The failure to abide by a SBREFA panel and process is a significant risk to the agency's rulemaking. The insufficiency of the 1022 analysis through qualitative rather than quantitative analysis is a real risk. And given the public statements made, including at the State of the Union, I think there's real prejudgment risk about where the Bureau is going to come out in this rule.
Thank you. I would like to yield back the balance of my time to the chair.
Thank you. Thank you to the gentlelady. And following up with Mr. Hempler's testimony, Director Chopra has defended his regulation without rules approach by claiming that guidance and interpretive rules, blog posts, and press releases merely respond to what the private industry is asking for. Just to give more clarity, the question is, has Director Chopra's guidance and blog posts, have they enhanced clarity or made things more confusing about what the legal requirements actually are?
More confusing.
And Mr. Johnson, are these blog posts and informal proclamations designed to commit institutions and credit providers to new legal obligations?
They often do, although they're kind of sold on the guise of something that does not.
Thank you. The gentlelady's time has expired, and now the gentlewoman from New York, Ms. Velasquez, is now recognized.
Thank you, Mr. Chairman. I'm sorry that my colleague Juan Vargas left, but he brought up Mr. Mulvaney and how fun he spoke about him. I just wanted to remind him that an investigation by the Inspector General at HUD revealed that Mulvaney was responsible for withholding funding that was allocated by this Congress to help the people of Puerto Rico after Hurricane Maria. And that investigation revealed how President Trump told him, Mr. Mulvaney, that he didn't want a single penny to go to Puerto Rico. And he did exactly what President Trump asked him to do, with total disregard to the fact that 4,000 Puerto Ricans, American citizens, died because of Maria. And here was the president telling Mulvaney, and he didn't have the courage to say to the President of the United States that that was morally wrong. Anyway, Attorney General Ellison, Congress established the CFPB to provide a single point of accountability and to work across all states and jurisdictions to enforce federal consumer financial laws and protect individuals and families from predatory actors and wrongdoers. As the highest law enforcement officer in your state, can you explain the areas on which you have collaborated with the CFPB?
Thank you, Congresswoman. I'll tell you that we've had extensive cooperation around student loan debt. We've had a number of conversations that have helped guide us. We've collaborated across multiple states with the CFPB. I can tell you that they are an excellent partner.
So what has you and your staff interaction with the CFPB been like?
Well, it's been very positive. As a matter of fact, one of the things that I shared in my comments is October 2019 matter that involved North Carolina, the city of Los Angeles, when we sued a series of companies and individuals running a fraudulent student loan debt relief scheme that falsely promised to help people to pay off their student loans and obtain student loan forgiveness in the process. And I can tell you that we were able, with the CFPB and with the assistance of the CFPB, to give restitution and relief to, literally thousands of people to the tune of millions of dollars. So we are very confident that the CFPB is meeting its mission and its goals.
And in this era,
Could someone close the door, please?
thank you.
Thank you. And once we close the door, the gentlelady will be given more time.
Thank you. Mr. Ellison, it's so great to see you. Can you remind, in this era of misinformation, can you remind members of this committee, perhaps, who weren't here during that time, why it was important to create an agency like the CFPB?
Well, Congresswoman, as you know very well, there were a number of agencies assigned the responsibility of consumer protection. So many that nobody really took it seriously. Others had dual responsibilities like prudential and soundness responsibilities and consumer protection. Consumer protection invariably took a back seat to those considerations. And so we believed that it would be good to consolidate that responsibility in one place. And we also concluded that we didn't want the agency to be subject to agency capture. We all know on both sides of the aisle that an agency can be subject to capture. None of us want that. We want the agency to do what it's there to do. And so I think, Representative Foster made a great point. Would it be a good idea to be able to go to the Fed and say, raise interest rates or we're going to cut your budget? That's a bad idea.
Thank you. And you and I have worked most of our careers to root out and combat discrimination in lending. I know the CFPB is close to finalizing its Section 1071 rulemaking, which will require lenders to collect and report demographic data of borrowers that apply for loans to start or grow their businesses, and shine a light on lending disparities. Some claim that this will create more discrimination and lead to less lending. Do you agree with this assessment?
I think it'll really help us find out how well we're doing in the area of equal opportunity, and I welcome it. I think it's a good proposal.
Thank you, Mr. Chairman. I yield back.
The gentlelady yields. The gentleman from Florida, Mr. Donalds, is now recognized.
Thank you, Mr. Chairman. Thank you, witnesses, for coming. Attorney General Ellison, welcome back. Good to see you here as well. Let me be very clear with everybody here. I am the sponsor in the House for the bill that repeals the CFPB. So I want to just level set for a moment. I'm not a fan of the agency, never was. I actually am glad that members have talked about the history of how we got to this point. I was actually a part of the commercial banking industry from 2003 through 2007. I was watching, is actually my first, Mr. Chairman, it's actually my first congressional committee I ever watched as an American citizen was the House Financial Services Committee, because I was actually an industry participant. I worked in the industry. So I saw the deliberations about TARP and all that stuff, and then the deliberations on Dodd-Frank. One of the issues for CFPB is that it is a highly partisan agency because it was created under partisan parameters. It was one-party vote, one-party rule that created CFPB. If you were to ask me if the CFPB is unconstitutional as a whole, I would say yes, because the way I view it, there is no oversight, obviously. Its funding comes out of the Fed. We all know that. If you ask Chairman Powell, he doesn't know how much money goes into the CFPB. A letter shows up, they say okay, they get their money, they go on about their business. So there is no oversight of CFPB at all writ large. It appears to be a freelancer more than a regulator. It goes and it roams the countryside looking for products that may or may not pop up, and then it decides, frankly, at the direction of the director if it likes the product or not. That is not a regulator. That is a freelancer. And so, a couple questions real quick. Mr. Hempler, do vehicle loans pose a systemic risk to the American economy?
No.
Mr. Johnson, do credit card late fees pose a systemic risk to the American economy?
No.
Let me ask you this question, Mr. Johnson. Are there serious issues about not only separation of powers, but due process at the CFPB, and can you detail them?
Congressman, I have in my extended written statements, I've provided a list of roughly 30 instances that, in my view, constitute due process or separation of powers concerns, or the Bureau overreaching its statutory authority.
Can you go into detail about one of your comments where they pressured financial institutions to waive attorney-client privilege during supervisory examinations?
Sure. So the Supreme Court has been very clear that when Congress enacts a statute, including the CFPB's enabling statute, if it wishes to abrogate a common law privilege, and especially one as foundational as attorney-client privilege, it must do so expressly. So there is no express abrogation in Title 10 of attorney-client privilege. In other words, the CFPB lacks authority to compel institutions in any capacity to waive attorney-client privilege. It's especially troubling in the context of supervisory examinations because all of that communication with the Bureau is secret and can't be made public. And so there's a ripe opportunity for the Bureau to pressure institutions in a non-public
Mr. Johnson,
setting
I got to cut you off. And I thank you for the more layman example because I'm not an attorney. You know, I'm a finance guy, so I appreciate that. Thank you. Mr. Attorney General, do you think it's okay for the CFPB to force financial institutions to waive attorney-client privileges?
I think it would depend, but I'd like you to prove that that is in fact what is going on. I think you need to demonstrate that. I mean, that's an allegation, but I'd like to know what facts you're using to make that claim. And I think certainly there are occasions in which the attorney-client privilege is not, I mean, I've been an attorney for 30 years, and I can tell you that there are occasions in which that veil is pierced. Depends.
All right, I'm going to ask you one final question because actually in your testimony, and you've been citing it about the work that you did with CFPB, your state, and I forget the other state that was involved with respect to the student loan fraudsters. And actually, I do want to thank you for prosecuting that because we should not have, fraudsters roaming through the financial landscape. Everybody, I believe, agrees with that wholeheartedly. So when we find that stuff, we have to root it out of the system. Totally agree with you there. You also state that the CFPB's civil penalty fund secured $95 million in refunds for the affected parties.
That's right.
Because the perpetrators obviously didn't have the funds to pay people back.
Right.
Where does the CFPB get its money in the civil penalty fund?
Yeah, well, it gets the money through the resolution of other matters, and so that's...
So fines levied on other institutions were then used to give out rewards in other areas?
Right,
Okay.
which is an appropriate thing to do and happens all the time.
All right, I yield back.
The
Thank you.
gentleman's time has expired. The gentleman from Texas, Mr. Green, is now recognized.
Thank you, Mr. Chairman. Thank the witnesses for appearing today. Especially thank Mr. Ellison, Attorney General Ellison, for appearing. It's just good to have him back. He used to sit right next to me for years. Always had things that were important to deal with, and I'm not surprised that he has become Attorney General. Capable, competent, and qualified. Welcome home. Mr. Hempler, dear sir, would you kindly explain to us how a service member can receive a reduction to 6% on a pre-service loan? And if you can be terse and laconic, I would greatly appreciate it.
I will try, Congressman. A service member who receives active duty orders can submit those orders to his lender and immediately receive a reduction to the statutory limit under the Service Member Relief Act to 6%.
And if that service member has multiple loans, if the service member complies, as you've indicated, the loans would be reduced to 6%, all of these various loans. Is that a fair statement?
That's correct.
And the CFPB has indicated that if the service member does as you've indicated with a single loan, that would then apply to other loans. Is that a fair statement?
What the CFPB has put forward is a request of industry to essentially ping the Defense Department.
Excuse me, if I don't mean to be rude, crude, and unrefined, but is it true that if the service member applies and complies, as you've indicated, with one loan, the CFPB has concluded that
No.
that can apply to others?
No.
Okay. What have they concluded?
They have put forward that What the industry needs to do is regularly go into the Defense Department database and look for active duty orders of service members. So they don't have to comply with the statutory requirements at all to notify lenders.
Well,
Pro-
do
the
they,
problem with
excuse
this-
me if I
Sure.
may, do they indicate that one loan must have been, there must have been a request for a loan?
No.
No loan at all? Look for the loans and reduce them?
The industry is supposed to look into this database that, quite frankly, is down on a regular basis. Currently gets about 40,000 pings monthly. Annually. What they've asked the industry to do is now take that up to 120 million pings annually. The Defense Department database cannot handle that, and quite honestly, it doesn't have the security precautions that's necessary for this type of work.
How would it harm the service people if the Defense Department, or if there is compliance with what the CFPB has recommended?
If industry pings it and does not find a service member's active duty assignment, and thereby the extension is not granted, but somehow that is not accurate, the service member doesn't receive the relief they should get if they were to pursue this as the statute requires.
Well, the service member would get loans reduced if the industry complies with the request of the CFPB.
I'm not sure I understand.
Well, you've said that the service members, the CFPB has asked the industry to look into these loans and make the reductions when they find that there is such a loan.
Yeah. Essentially the database, like I said, is down on a frequent basis. It
Well,
was actually
let's
down
assume
this
that
week.
it's functioning for
More
our
often than
purposes.
not, it's not
For our
functioning.
purposes, let's assume that it functions. If it functions, would the service members benefit?
Congressman, my point is that we can't assume that it's functioning, because if my members
Well-
assume that it's functioning and it's not, we're the ones that are accountable.
I understand. But when it does function, do the service members get their loans reduced when they apply?
If everything is accurate, yes.
Thank you, Mr. Chairman.
Thank you. The gentleman's time has expired. The gentleman from Tennessee, Mr. Ogles, is now recognized.
Thank you, Mr. Chairman. To our panelists, to be or not to be, that is the question. So I'll borrow from Hamlet, from Shakespeare, as Hamlet contemplates death. And I can't think of an agency that should meet a quicker end than the CFPB. I can't think of an agency whose regulatory authority could be delegated to other agencies as quickly and efficiently as those of the CFPB. So the question is, let's say we disagree on that point. I think we can agree that any agency, regardless of funding mechanism, that is out of control, that has usurped its authority, should be brought to bear and feel the full weight of Congress and the appropriations process. Last year, the CFPB chose to completely transform fair lending policy without any kind of public input. They also didn't give any prior notice to stakeholders who would be impacted by this change. Is it appropriate for a federal agency like the CFPB to upend transparency, as it did, by undermining the Administrative Procedures Act, the APA? Mr. Hempler?
No, it's not fair, and that's our whole testimony today, Congressman, is that we're looking for clear, understandable rules from the CFPB, as the director said his intention is.
Mr. Johnson?
If the agency wishes to impose new burdens on anyone, it should do forthrightly and in compliance with the APA.
Ms. Thompson?
These raise constitutional concerns, including the major questions doctrine, and is ripe for consideration by the Supreme Court.
Mr. Watkins?
The regulated industry should only receive what is unlawful from Congress or through the process that Congress has mandated.
Before I get to my next question, I did want to revisit the idea of the process by which service members have reductions in loans. Would you like to clarify, Mr. Hempler?
I don't believe what Congressman Green put forward would require under the CFPB's proposal for the service member to put forward their active duty assignment to a single creditor or lender. But even if that were the case, by logical conclusion of what he and I were discussing, every other creditor would be subject to knowing that the service member had put that forward to that particular creditor, totally uninformed, but at the same time accountable.
So what you're saying is that you don't think the federal government should be poking around in your personal business?
The statute is a great statute to protect service members. The statutory requirements are that once the service member gets his or her assignment, they can then present that to the creditor and get a reduction. Nobody takes any exception with that. Trying to figure out willy-nilly by somebody, posting it in the cloud doesn't make any sense in terms of regular order.
Well, last year the CFPB unilaterally decided that Dodd-Frank's grant of authority to prevent unfair, deceptive, or abusive acts or practices, known as the UDAP, now includes controversial disparate impact liability. The Bureau announced this change by press release. So on this point, or really any other, is it fair, by way of press release, that an agency can transform industry and industry practices without due process and notice? Never mind the fact that Congress didn't get a say. Mr. Hempler?
Congressman, that's a wonderful question. What we're asking for is fairness from this regulator. Having to follow supposed rules by press release. How do you challenge a press release? How do you challenge a news conference? You can't. It's only through APA rulemaking authority that you can have the meaningful back and forth between regulator and the regulated entity.
Mr. Johnson?
The short answer is it's not fair.
Ms. Thompson?
Not only is it not fair, but CFPB should only exercise the power delegated by Congress.
Mr. Watkins?
Constitution requires notice before due process can be found for someone to have violated it, and blog post is not proper notice.
I thank you all for being here, all of you. Mr. Chairman, I yield the balance of my time.
Gentleman has yielded. The gentleman from California, Mr. Sherman, is now recognized.
Thank you. It's interesting to find out there's a database of service members. That's interesting in the financial services area. I sure hope our friends over at Armed Services are looking at from whether that is a national security concern or a privacy concern. I'm a nationalist. I like it when we have the same standards nationwide. I realize, however, that if the CFPB doesn't do its job, there's going to be even more pressure for the states to do their job. Mr. Ellison, you know something about state government and consumer protection, and welcome back.
Thank you.
If CFPB is not as effective, do you see your state and other states being more involved? And would those regulations tend to be disparate, so a business would have to deal with perhaps 50 different sets of regulations?
Congressman, I think that is an accurate description. You would create a very hard to predict patchwork from state to state, and I'm sure that would not please industry to have to deal that way. But I also would say that our staffs are not, some of our staffs are fairly limited, and so it would mean that people are just getting away with things they shouldn't be doing and are against the law.
And some states would not step forward even when they should. One of the advantages of having national standards is sometimes those standards may not be quite as high as somebody in Sacramento would like, but there are an awful lot of Americans who live in states that don't provide much protection at all, and at least we raise the floor for the whole country. Mr. Hempler, can you explain why lenders in some industries would have higher default rates than those in other industries?
Mr. Chairman, if I may expound on
And you may have done that earlier. I realize that
Yeah,
I've had
no,
to come late to this hearing.
Mr. Ellis was talking about what industry wouldn't like. And the American Financial Services Association represents both banks and finance companies, and I could tell you that our national finance companies deal with 50 sets of state regulations, the quote work that he mentioned. The certainty that we have in those states, all 50 of them together, is still better than the uncertainty that we have by virtue of press release from the CFPB. With respect to your question about default rates, I didn't quite understand what you were...
Can you explain why some lenders have higher default rates than other lenders?
Some lenders go deeper into the credit spectrum than others.
So they're willing to make loans to
Yes.
a group of people knowing that, well, if we design our standards this way, we'll be able to make 100 more loans, but out of those 100, we may have 3%, 5% defaults that we wouldn't otherwise have.
Correct.
We're talking about higher interest rates. How is that going to affect both here the companies you represent, but more importantly, the consumers that they serve?
Well, Congressman, each creditor serves a different niche in the market, and our industry is committed to access to credit, and to do that, folks need to take on varying levels of risk, and in order to offset that, you have to charge different rates in order to get to the same sort of outcome, performing loans. Even if folks are having a 20% default rate, which is huge by any estimation. I respect your reaction. That still means that 8 out of 10 people that otherwise wouldn't get access to credit are getting access and performing on those loans.
And the natural thing is we want all of our constituents to get loans, even those in where the statistics would indicate there's a somewhat higher rate of default, and we want all our constituents to get the best possible, lowest possible rates. And obviously, you can't always do that. I just want to point out that I know the courts are going to decide this issue about the powers of the CFPB. I'm glad that isn't being decided here in this room, and we as a committee have to be able to react. But I think having a single national organization setting the standards, and of course doing so in a way that the courts find is appropriate, is a good thing, and I'll yield back.
The gentleman yields back. Now the gentleman from Wisconsin, Mr. Fitzgerald, is recognized.
Thank you, Mr. Chair. In 2018, Economic Growth, Regulatory Relief, and Consumer Protection Act provided relief from the harms of Dodd-Frank to community banks and credit unions who had nothing to do with financial crisis. However, many of these small financial institutions, they still face, as has been discussed today, the daunting regulatory compliance challenges. In particular, the CFPB has abused its authority to advance a political agenda and harms small businesses in doing that. Congress repeatedly has urged the CFPB to narrowly tailor its rules to specific consumer abuses. When the Small Business Regulatory Enforcement Fairness Act, or SBREFA, the worst acronym in banking, was enacted in 1996, Congress intended to ensure federal agencies throughout would understand and thoroughly work their rules to see how it would affect small firms and uses, and the use of that information to eliminate unnecessary burdens. We had discussions about this in the Small Business Committee in last Congress. Over time, SBREFA process has been treated as merely a check-the-box initiative where outreach is made to the small entity representatives, which otherwise is called the real people on the street, but their feedback is not adopted in the final rulemaking. That's why last Congress, I, along with some other members, introduced Making the CFPB Accountable to Small Business Act. The bill would require the CFPB to presume that size and sophistication-based tailoring of regulations are needed in SBREFA panel reviews. If tailoring is not undertaken by the panel, then they must issue a justification, which would be painful for the CFPB. Just a quick question to anyone on the panel, but I'll start with Mr. Johnson. Can you just talk a little bit about that process that otherwise is just check the box kind of exercise?
Well, it's critical that the agency undertake it, and if there's ever a question about whether it should or not, all it is an additional process that the agency fundamentally benefits from, because they're hearing that type of information that they wouldn't otherwise hear as part of a rulemaking process. And by definition, larger institutions have the capital base over which to spread the cost of compliance, and so the agency needs to pay critical attention to the smaller market participants that lack that capacity, so that the impact of the regulation itself is not creating an uneven playing field.
Ms. Thompson, do you have a comment?
I'd just like to emphasize the fact that compliance cost falls especially heavy on some of the smaller financial institutions who provide credit to people who may not otherwise have access.
Mr. Watkins, you want to talk about that?
I'm in agreement. The small institutions just can't afford the voluminous number of regulations and trying to go through all of them. It adds cost with each one of them. For large financial institutions, that cost may be a very small percentage. For small, it can be much larger.
Very good.
The gentleman yields back. Well, I appreciate the witnesses' testimony today. I want to thank all of them for their expertise and offering their testimony. I think a takeaway is that if there was ever a federal regulatory agency that needed greater scrutiny, more accountability to the American people through their elected representatives in Congress, subject to the appropriations process, this agency is it. And I'll just say as a final parting point, if any agency pronouncement, whether it's an interpretive rule, guidance, a blog post, a speech, or a press release, creates new legal duties, then it must do so within clearly delegated authority from Congress, subject to the West Virginia decision, and it must comply with the Administrative Procedures Act and notice and comment rulemaking. Otherwise, it is not constitutional, and it is a violation of basic administrative due process fairness. So with that, we want to make sure that the CFPB changes its behavior in compliance with the law. And without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witness for the response. I ask our witnesses to please respond as promptly as you are able. This hearing is now adjourned.